Everything explained in this video is summarized from the CoinMarketCap. And also, please don't forget to like and subscribe to my channel for future XRP news and some other cryptocurrency news in general. Now, take a look at this. Is it game over? Latest rumors suggest SEC dropped certain claims. Before we move further, there is a new crypto airdrop now taking place on Telegram, which is about to launch anytime soon. Please make sure you participate in this airdrop. The link is in the description of the video. Don't miss out on this. Now let's continue with our video. A few days ago, the Securities and Exchange Commission sent a notice of appeal to the Second Circuit Court in the ongoing litigation between Ripple and the SEC. The appeal focuses on three main points: the distribution of XRP to employees by Ripple, the sale of XRP through exchanges, and the sales made by CEOs Brad Garlinghouse and Chris Larsen. The court has not received the acknowledgement and notice of presence by the due date of October 18, 2024, according to a recent post on X. The note of appearance and acknowledgement are both relevant to the case. A dramatic conclusion was offered for the Securities and Exchange Commission C in the article, which stated game over SAC. In response, Mark Fagel, a former attorney for the Securities and Exchange Commission, made it clear that this circumstance is unrelated to the SEC. The defendant, Happily Larsen, whose legal counsel has failed to make a timely presence in the proceedings, was something that he mentioned as being relevant to the situation. Another person inquired about the matter by pointing out that the title of the lawsuit is Securities and Exchange Commission versus Ripple Labs, and that they did not see Chris Larsen's name mentioned in the case. The fact that they believed the SEC had abandoned its lawsuit against Brad and Chris was another argument that they brought up upon receiving the user's observation. Mark responded verifying it. Even though the letter itself does not include any names, he added that the docket sheet that he gave contains all of the necessary information, clarified that the remaining individual allegations against the individuals were still live, even though the SEC had dismissed specific accusations against the individuals linked to aiding and abetting Ripple's illicit institutional sales. A further point to consider is that institutional investors are showing an increasing interest in XRP. Recent filings by Bitwise indicate that they want to launch an exchange-traded fund at Delaware for XRP. However, this filing has not yet been submitted to the SEC and may be subject to delays as a result of the ongoing appeal. In the ongoing legal struggle that Ripple is having with the SEC, the company is taking decisive action. Chris Larsen, one of the co-founders of the company, has submitted an important document to the court just as the deadline for a crucial filing is drawing near, following a warning issued by the Second Circuit Court of Appeals regarding procedural issues about Ripple's case. This step in the process has been taken. Can you provide an update on the latest developments in the SEC case? Ripple was reminded by the Second Circuit Court of Appeals on October 22 of the significance of completing its Form C submission for the filing of a cross appeal against the Securities and Exchange Commission. The rapid action that Larsen took consisted of presenting an urgent motion to speed up this process in advance of the deadline that was approaching. Will Ripple be able to meet the deadline for Form C? Ripple must submit the Form C document by the 24th of October to preserve its right to appeal the decisions made by the SEC. If Ripple fails to meet this deadline, it may be unable to retain the right to provide an oral defense in court. Stuart Alderodi, chief legal officer of Ripple, highlighted that the submission of Form C will not change the current classification of XRP as a non-security. This classification has been in place at the moment because the verdict that has already been made respecting XRP is still enforceable under national law. He pointed out that it is difficult for the SEC to achieve the objectives that it had intended at this level. What does this perhaps mean for the future of XRP? The neighborhood surrounding XRP is keeping a close eye on the progress of the case. A favorable verdict for Ripple might result in a considerable increase in the price of XRP. Some fans have predicted that the price may even return to its previous all-time high to reach ambitious amounts such as $17 in the future. The filing made by Chris Larsen demonstrates Ripple's dedication to the issue at hand. The opportunity to present a defense may be lost if Form C is not submitted by the deadline of October 24. According to Ripple, XRP is considered to be a non-security under the laws that are now in place. If the case is successful, it might have a significant effect on the value of XRP on the market. The preemptive measures taken by Ripple reflect a significant turning point in the company's legal path. The decision of the court to rule in favor of Ripple might result in a significant increase in the performance of the XRP market, which would be a reflection of the community's optimism regarding the future of the cryptocurrency. The legal struggle that Ripple is engaged in against the SEC is seen as significant development. Around the time that the deadline was drawing near, Chris Larsen, who was one of the founders of the company, handed over an essential document to the court. A notice of appearance was submitted by Larsen before the filing of Form C. This action was taken in response to the warning issued by the Second Circuit Court of Appeals on the procedural errors that were associated with Ripple. Most recent developments in the SEC's Ripple case on October 22. The Second Circuit Court of Appeals sent Ripple an important reminder regarding the SEC litigation that they were involved in. For the cross appeal against the SEC, it was indicated that Ripple had to finish submitting its Form C just before the deadline. Chris Larsen submitted a move to expedite the procedure, which was considered an urgent motion. In the case of Form C, time is running out. Before the 24th of October, Ripple is required to submit the Form C paperwork to file its cross appeal against the SEC. There is a possibility that Ripple will lose its right to an oral defense if it does not present its documents on time. Ripple's chief legal officer, Stuart Alderodi, has made it clear that the submission of Form C would not have any effect on the decision on whether or not XRP is considered. XRP is not considered a security, according to the verdict that is still in place and recognized by the legislation of the country. In addition, Alderodi mentioned that it would be challenging to get the results that the SEC is looking for at this point. The case's destiny and the influence it will have on XRP, the community of XRP users is waiting with bated breath for the verdict in this case. It is anticipated that the price of XRP will significantly increase if the case is dismissed in favor of Ripple. There are even speculations that XRP could exceed its former all-time high, with some individuals thinking that it could hit $17 in the long term. The representatives of Ripple have stated that they have not committed any faults in the case's procedures. The corporation asserts that the cross appeal is being filed to remove the sanctions that have been set by the SEC. The most recent action taken by Ripple is regarded as a key step in the case, as stated in the conclusion. It is anticipated that the value of XRP will significantly increase if the verdict is in favor of Ripple. As Ripple co-founder Chris Larsen makes a significant legal move, the continuing case between the Securities and Exchange Commission and Ripple is getting closer to a crucial point. To avoid a default in the company's cross appeal against the United States Securities and Exchange Commission, Larsen submitted a notice of appearance just a few days before the important deadline for Form C, stating that this action is being taken by Ripple to put an end to the enforcement measures taken by the SEC and to safeguard its significant court victory concerning the non-security status of XRP. The information that has been provided is not intended to be trading advice. There is no responsibility for any investments that are made based on the information that is provided on this page. Before making any decision about investments, we strongly advise conducting independent research and consulting with a knowledgeable professional.